Lordship, I'd like to mention item number 2 and 3.
2 and 3.
Yes, Your Lordship.
Yes,
The leading counsel is out of session, so I pray that it will be listed after 2 weeks.
after 2 weeks.
Yes.
You are Kate Aza.
Yes, I'm Ketaga. Ketagang is the leading counsel.
The Learned Counsel Kate Aza. Have you informed the other side?
Yes, I'm informed.
The Learned Counsel Mr. Kate Aza appearing for the appellant. Raised for an adjournment and also submits that he has already informed the other side. Accordingly, the matter is adjourned to the least after 2 weeks, along with item number 3.
Thank you.
May I plead your lordships?
Yes.
My lord, I'd like to mention item number 11, my lord.
Item
This
number
matter, item number 11, my lord.
11.
11, my lord. This matter will be taken up after 4 weeks, my lord. I've taken consent from the petitioner. Appellant, my lord.
Item number 11.
PIL, my lord. Sunday Bagang, my lord.
The Learned Counsel MS
Tiwang, my lord.
appearing for the petitioner.
No, my lord. I'm for the respondent, my lord.
For the response.
State respondent, yes, my lord.
For the respondent. Raised for an adjournment and also submits that she has already informed the other side.
Yes, sir.
According to the matter stands adjourned to the least after 4 weeks.
Yes.
May I please, your
Yes.
lordship, I have informed the other side also, lordship. Item number 10, your lordship,
10.
10, your lordship. In that case, your lordship, we are contemplating to file additional affidavit. For that reason, 4 weeks' time may be granted to lordship.
We Learned Counsel Mr. A. Kumar.
AK Singh,
A.
lordship.
Singh. Appearing for the petitioner submits that he wants to file an additional affidavit
Lordship,
and therefore pays for some time.
lordship.
You are for the respondent,
Yes, my lord. For state respondent.
state respondent.
Yes, sir.
Also heard the Learned Counsel so and so appearing for the state respondents. The prayer Mr. Singh is allowed least after 4 weeks.
Lordship. Also.
Lords, I'd like to mention item number 9. Leading counsel AK Prakash, though, he got some health issue, so he cannot appear. Kindly, the matter may be fixed on 28th of July.
28th of July.
Yes,
Who is coming?
AK Prakash, though.
AK Procaster. The Learned Counsel so and so. Appearing for the appellant. Submits that the Learned Conducting Counsel, Mr. AK Procaster, is absent today. And for underground and adjournment will be prayed for. RMS so and so appearing for the state respondents. The prayer of the Learned Counsel for the petition is allowed least on 20 July.
Yeah, Lordship. Lordship, I'd like to mention item number 8, Lordship.
8.
Lordship. Is the counsel for the appellant is out of station, Mr. N. Para.
And Pada is absent.
Lordship.
What is your name?
J. Saro.
The Learned Counsel says J. Salu. Appearing for the appellant submits to the Learned Conducting Counsel, Mr. N. Pada is out of station. And underground and adjournment will be prayed for.
Lordship, 1 week leads after 1 week.
Huh?
After 1 week, Lordship.
Apani.
Lordship.
The prayer for adjournment is allowed least to next week.
Obliged. Yeah, my lord. I beg to mention item number 14. Since the leading counsel is absent, leading counsel is ex-Gyati, he is absent because, sorry,
SB Darang is absent.
No, you're,
Ex-
I'm the amicus.
Oh, you are
I'm for the informant.
Oh, you're for the informant.
Yes,
Who is the counsel for the informant?
Xavier.
Xavier Gyati, ex-Gyati.
He's absent.
Yes, due to his health issue.
What is your name?
P. Takar.
Learned Counsel, Mr. Peter. Appearing for a private respondent. Submits that the Learned Conducting Counsel, Mr. Xavier Gyati, is not available today. And on the ground adjournment and break. I have heard the Learned Amicus.
My lord, item may be listed after 2 weeks.
SB Darang.
Yes, Your Honor.
The prayer for adjournment is allowed.
Lordship, I beg to mention item number 6. I'm for behalf of the senior counsel Dilip Mazumdar, Lordship.
6 is listed with 5.
6, Lordship.
You're for 6.
Yes, Lord.
Then who is for 5?
I'm for 6, Lord. Due to
In
some
item
personal
5,
difficulty.
Mr. Soikia appears, R. Soikia.
So
5, in fact, 7 is also connected.
connected
I appear for a private respondents in 5 and 6.
in 5 and 6. We are asking for adjournment.
Yes, Lordship.
Do you have objection?
Matter will be fixed after 3 weeks, Lordship.
Item number 6.
Yes, 6. I'm for 6.
So 5, 6 and 7 didn't have to go, they are connected.
5, 6 and 7. 5, 6. What is your name?
P. Bagang.
You are for the petitioner.
Yes, I'm for appellant, Lords.
Mentioning
My
on
name
behalf
is-
of London
yes,
Senior Counsel
London.
D. Majumdar in item number 6 for the
Oh,
appellant.
The learned counsel, Mr. Soyensu. Appearing on behalf of Mr. D. Mujumdar, the learned senior counsel of the appellant, prays for an adjournment. I have also heard Mr. D. You're also here.
Yes, I have for the private respondent in item number 5 and 6.
Heard Mr. D. Pangi, appearing for the private respondents. The prayer for adjournment is allowed. When do you want it?
After 3 weeks, Lordship.
Least after 3 weeks, along with item number 5 and 7.
Yes. Obliged.
Deeply obliged.
Is there any interim order?
May I please, your lordship,
Yes.
your lordship, I beg to mention item number 15, your lordship.
15,
Yes, I am for the applying, your lordship.
yes.
Your lordship, just recently we have received the paper book, so we need some more time, your lordship. So your lordship may give us a fixed date.
What is your name?
A Talom, your lordship.
The learned counsel MS A Taram. A
Talom,
Talam. 15. Appearing for the appellant submits that she has received the paper book recently only, therefore she needs some time to go through it. Heard Mr.
Lordship.
Heard Mr. So the learned public prosecutor for the state of Arunachal Pradesh. The prayer of the learned counsel for appellant is allowed. Least up to 2 weeks.
your lordship may fix on 7th of this August, your lordship.
Least on 7th of August for him.
Much
Lordship, in this matter, it is represented by this Mahmoud Pasha from Delhi. Whether he will be appearing or not by online. If he is not appearing, matter may be adjourned.
Who is appearing?
Mohammed Pasha.
Mohammed Pasha.
Yes, from Delhi.
Prasad.
Yes, Pasha.
Pracha.
Yes, Pasha.
Parsha.
Yes.
The learned counsel, Mr. P. Tapak. Appearing for the petitioner submits that in this case, the learned counsel, Mr.
M. Pasha.
M. Pasha.
Ah.
Will appear. But today he is absent. Therefore, Mr. Tapak prays for some time. But the learned counsel is M. Kato, the learned government advocate for the state of Arunachal Pradesh. The prayer of Mr. Tapak is allowed. When do you want it?
After a week.
Least next week.
Yes. All right.
If it is in the position of fight.
In fact, we have made communications to the ministry. But so far, my lord, we have not received the instruction from the ministry. So therefore, my lord, may I please, my lord, some more time may be granted so that my lord, the effective communication can be made. My lord.
Appearing for the Union of India. Prays for some more time
My lord.
to file the affidavit in opposition. RMS,
Tirimi.
appearing for the petitioner. The prayer of Mr. Kapoor is allowed.
My lord.
Least
Okay.
after 3 weeks.
My lord, I am audible, my lord.
Yes.
Well, I was in item number 4, my lord. I was disconnected, my due to some network problem. I am sorry, my handicap position, I cannot remove my eyeglass, my lord. So I
You
was
also
going to
appearing for
petition.
item number
I am
4.
I am petitioner, my lord.
You are
I
a
am petitioner.
petitioner.
Yes, my lord.
Oh, then, the land council, Mr. P. Mohanto. Appearing for the petitioner. The prayer is allowed after 3 weeks.
Well, a date may be given, my
Okay.
lord.
Date cannot be given in these matters. After 3 weeks.
My lord. Master.
My lord, in this case, IA has to be listed for condonation of delay, but the main case has been listed. On last occasion, they have filed the IA along with the memo of appeal, my lord.
Oh, okay.
IA 50.
I think it's good today
For condonation of delay, my
for
lord.
condonation of delay. One year, 9 months.
Yes, 1 year, 9 months. This is a jail appeal.
Jail appeal, my lord.
Huh?
Jail appeal.
For jail appeal.
Yes. On the last occasion, notice was to be issued to the respondent, the informant.
Hmm.
And it seems somebody has filed wakalanam on their behalf. But I don't see anyone appearing.
So somebody filed a color number.
Yes.
The color number filed on behalf of the informant. One chance I will give.
Yes,
your lord.
yes, of course.
Heard Mr. N. Dungan, appearing applicant, I heard Mr. P. attended on condition for prosecutor for a state of bonus securities. None appears for the informant. So wakalat number has been filed on behalf of the informant. One opportunity is given to the informant to appear and contest this matter. Least after 2 weeks.
My lord, along with the IA, main appeal.
I am passing the order in the eye.
Okay,
Yes. All right.
all right. Oblige, ma'am.
I appear for the private respondents, the petitioners. Union of India is represented by former additional solicitor general. I was just informed by his junior that they're going to appear online. I don't know what's wrong.
Oh, today none.
They were supposed to take time, in fact.
Oh. Okay, then none appears for the appellant.
Yes.
None appears for the appellant. Or Mr. Deepangi, appearing for the private respondents.
Yes.
Since none appears for the appellants on call, the hearing is adjourned today. Least after 3 weeks
None.
for hearing.
Oh.
Finished. Yes.
May I, Lordship? Lordship, I'd like to mention item number 21, Lordship, of today's hearing.
21.
Yes, Lordship. It may be taken after weeks, Lordship.
Criminal appeal.
Yes, Lordship.
Lordship, I am for the appellant here. You are for the appellant? Yes, Lordship. MS L. Hage, deal and additional public prosecutor, praise for an adjournment. Heard Mr. Gini.
Yes, Lordship.
Appearing for the appellant, the prayer for adjournment is allowed, least up to 2 weeks for hearing.
Lordship. Obliged, Lordship.
Obliged.
May I please, your Lordship? Lordship, I would like to mention item number 15, Lordship.
15.
Lordship. Last time, Lordship, I was directed to make a correction in the form of filing an application that we are doing it today, Lordship. Can this matter be posted day after tomorrow, Lordship? I'll be doing it today, Lordship. I'll be filing that application.
On the request of the learned counsel, Mr. J. Gini, the matter is adjourned today. Please day after tomorrow, give it a date.
Obliged.
My lord, I beg to mention one old matter, my lord, pending matter, my lord. Old
What's
is,
it?
my lord, this is about challenging we have filed this petition on behalf of the state, SIT, challenging the order of the trial court whereby the 302 section was dropped, my lord.
302 section was added
Was dropped, my lord, dropped
or dropped.
against the accused person. So we have challenged this, the order. So this matter is pending for long, my lord. So
Tomorrow?
tomorrow, my lord. Yes.
My Lordship. Lordship, I beg to mention item 16 and 17. Lordship, I am referring for respondent number 2. And petitioner, they're staying in Assam and they could not appear today. And the matter fixed on the 29th of this month.
Here for a respondent,
Respondent 2, Lordship.
respondent number 2. Your
And-
T Topu,
Yes, T Tamin.
T Tamin,
Yes, Lordship.
have you informed the other side?
Yes, yes. They have informed me to take adjournment. Kindly
The
fix-
learned counsel, Mr. T Tamin, appearing for the private respondent. Raised for an adjournment. He has also submits that he has already informed the other side. Accordingly, the matter is still settled today. Least after 3 weeks, along with item number 17.
Lordship kindly fix on 29 because
This month,
yes,
129. July.
highly obliged.
Your Lordship may pass over the matter. Council is on the way.
May I please, my lord? No, this is a regular bill application, my lord. At this stage, my lord, may be pleased to call for the case diary.
What Mr. J saying? Appearing for the petitioner. What the learned public prosecutor, Mr. What is your name?
Deloy.
Deloy. Call for a case day. When the diary will come?
Next week, Lordship.
28th, my lord. 28th of July,
28.
my lord.
List on 28.
Obliged.
Lordship, may I pray that this matter may be passed over for some time. The conducting counsel is in court number 2.
This is an application under 528, my lord, solely on the basis of settlement. The punishments are 6 months and 3 months, my lord. And the section which has been incorporated is 281 and 125, rash driving, riding in a public way. Solely on the basis of settlement.
They have compromised.
Yes, compromise.
Yes, your lordship, since they have settled the matter and your lordship, the section, the corresponding section is 279 is my lordship is aware on the under IPC. So in many occasions, your lordship, this court has your lordship interfere when the party enter into an agreement in this nature of case, your lordship. So I do not have any objection, my lord.
This cost. This follow.
My lord,
It's a bail application, my lord.
Hmm.
Earlier, this alleged accused, my lord, earlier it was released
Hmm.
by the trial court, my lord, having examined all material and records.
Hmm.
But later on, my lord, the complainant, my lord, they approached this honorable court
Hmm.
and accordingly for cancellation of the earlier bail granted by the trial court, my lord.
Hmm.
Thereafter, my lord, the earlier bail granted by the trial court was cancelled
Cancelled.
by this honorable court in the criminal petition, my lord, while exercising 482, my lord. Only basically,
How many witnesses are examined?
my lord, as of now, my lord, 14 witnesses have been examined. Now the remaining part is only the official witness, my lord, officer in charge and the DSP, my lord, all higher rank, my lord, all the material witnesses, including which they stated to be eyewitness, my lord, that has been already been examined, my lord. Now, an earlier ground, my lord, was that there's some eyewitness yet to be examined, and there's a likelihood of interfere with the process. There's a likelihood of influencing, my lord. Stating that he's the retired police officer. In fact, he is the retired constable, my lord. Now here, as of now, my lord, all the material witness has been examined, my lord. And as for material witness, we have annexed all the evidence also from PW1 to
I want to go to the evidence.
my lord.
So I will call for a scanned copy.
Yes, and my lord, my humble suggestion would be, my lord, since the bail cancellation was done by the one of the bench, coordinate bench, your lordship, it will be appropriate, your lordship, if this matter placed before the same bench. Yes, your lordship, because it was the cancellation is connection with the same FIR only, your lordship. So this matter may be placed before the same bench, my lord. My humble prayer.
No, you're correct.
Yes.
Heard Mr. T. Tagum. AP for the petitioner. Heard Mr. T. Ete, the learned traditional public prosecutor for the state of Arunachal Pradesh. This matter before the appropriate.
Yes,
bench.
my lord. Deeply obliged.
567.
May I please, your
Yes.
lordship, item number 5, 6, and 7 may be passed over for a while. Lordship.
I have
567, all are listed.
5, 6, and 7 may be passed over.
7.
You are for 5.
5, 6, and 7.
5, 6, and 7.
Yes, yes,
Argument for.
Huh?
It is 7 is all the connected matter.
yes, connected matters.
Connected matter.
Yes.
Same FIR.
Same. It's only the issue is this is a out of civil contract. There is no such criminal offense. Access. When you see the
Respondent number 2, who is for respondent number 2?
Respondent number 2, Lordship.
Notice served or not?
Yes, Lordship. Last occasion, they appeared, Lordship. Bakal number also been produced, and they're supposed to file objection, Lordship.
Tapak is for item number?
we can pick the matter for tomorrow.
Hmm?
The private party session is coming.
Private parties will be required.
Yes. Maybe required because he has already appeared.
Yes.
Today he is not appeared. For disposal tomorrow.
Tapak is for item number 7.
Because all the cases will take together out of same FIR, 5, 6, and 7. I'm appearing on behalf of Mustafa, item 7.
Item 7.
Yes.
In item number 5, we write the order.
But
Our
Lordship,
system-
all the Lordship matters are connecting, Lordship. They are judging out of same FIR.
Okay, we will wait for respondent number 2 for some time.
Lordship, pass for a day and that's
Tomorrow.
Tomorrow not possible. If he does not come on the next date, he will be
Lordship, I have been told to pass over for now only.
pass over for a day.
Yes, yes, pass over for some time. Yes,
Sometime. Who is coming?
yeah, he's coming.
Respondent number 2.
Respondent number, I don't know, Lordship.
That is the main problem. Respondent number 2 will be required. If he does not come, respondent number two.
Yes.
Then.
The
hearing
five,
cannot be
six
done.
lordship, the petitioner is different lordship, 5-6.
5-6 is different.
Yeah,
lordship.
5-6, also have, requested me to pass over the matter.
What a day.
Yeah. So I'm appearing for 5, 6, and 7.
What is your name?
Tita,
I'm for 7.
How does it?
5, 6, 7.
I'm 7.
You write the order in item number 5.
Respondent, yes. In 7, I'm respondent.
Respondent is appeared.
Huh?
Respondent.
You are for the respondent.
Yes, yeah, respondent.
Who is for the petition?
Respondent number 2.
You are for the respondent number 2.
Nalan Nigri.
Lordship, actually, this council lordship seeking time for the 5 and 6 for the petitioner and 7 for respondent.
No, item number 5, you are in.
You are for?
I'm for respondent, Lordship, actually.
Oh, you
I
are
don't know
for-
much about the fact of the case. Just I have been told to take pass over.
Respondent.
Respondent.
You are for the respondent. The petitioner is absent
Petitioner is-
in 5 and 6.
Yes, absent.
Item number 5, you write. Heard Mr. None appears for the petitioner on call. Heard MS H. Hagit, Delarned Additional Police Prosecutor for the State of Arunachal Pradesh. Heard Mr. You are appearing for whom?
Tinoma.
Noma.
Tachanoma.
Tochanoma.
Yes.
What is your name?
Yes, Lordship.
What is your name?
Tichita.
Appearing on behalf of Mr. Techanoma,
Tachanoma.
the elected counsel for the private respondent. Since none appears for the petitioner on call, the matter is adjourned today. List after 2 weeks, along with item number 6 and 7.
Obliged, lordship. Okay.
Your Lordship, if item number 8 and 9 can be passed over as well. The conducting counsel is engaged in another court, right? Obliged.
This is a regular bail application, madam. Trial is going on.
The trial has not started, my lord. So far, to my understanding, only the cognizance part has been taken. In this case, my lord, not into any other ground, my lord. I'm solely on the ground that the grounds of arrest, which
Who is for the complainant?
for the victim, my lord, on last 2 occasions, they have appeared, my lord. And in the last occasion also, the matter could not be taken up since they have not appeared. And my lord was the observation that if on the next date, amicus will be appointed, my lord.
Today I will appoint one amicus.
Amicus, my
Yes,
lord.
madam. Yes.
Heard Mr. J saying, appearing for the petitioner. Heard Mr. T. A. Delarned Additional Police Prosecutor for the petitioner. None appears for the complainant today. Therefore, what is the list of members?
My lord may appoint, my suggestion would be N. Dangin, my lord.
Huh?
N. Dangin, Nikita Dangin, she's independent.
N. Dangan. And Learned Counsel MS N. Dangan is appointed the amicus curiae to represent the complainant.
Yes.
Registration inform MS Dangan. List next week
Yes, your Lordship. Obliged.
On 30th, my lord.
on 38th.
Obliged.
May I please, your lordship, this is a regular bail. Your lordship is moved by the wife of the alleged accused. She is a housewife having 2 minor children. One of the minor child is a special child, lordship, and she is a housewife. On last occasion, your lordship, this honorable courts has called for the scanned copy of the trial records along with the case diary. Your
Lordship,
lordship.
case diary we have not received, lordship.
Scan copy not received.
No, lordship, case diary have not received yet. Lordship, it may be listed day after tomorrow, lordship.
Next week. it will be better.
Lordship.
Only 2 days, within 2 days, it may not come.
Yes, lordship.
Scanned copy of the
Case diary.
trial court record has not been received.
Lordship, case diary, lordship.
Huh?
Case diary.
Huh?
case diary of the scan copy of the case diary.
Scanned copy of the case diary.
Yes, Lordship.
Scanned copy of the case diary
Yes, Lordship.
has not been received.
And Lordship, as well, Lordship.
How many witnesses are examined in the trial?
Complainant statements already recorded.
Already recorded?
Yeah, yes, Your Lordship. And-
Complainant state.
Yes. Your Lordship,
Lordship,
may-
Your Lordship, scan copy of the trial court record as well as scan copy of the case diary.
Scanned copy of the trial court record as well as the scanned copy of the case diary
Yes, Lordship.
shall be called for.
may we fix in, may I please, Your Lordship, may.
Next
fix-
Monday.
Next Monday. Yes, next Monday is what? What's the date?
28th, Lordship, then.
Yes, sir.
Yes, Lordship.
I will be out of station, Your Lordship, I will be out of station.
Next Monday.
Yes, Lordship.
Then Tuesday, Wednesday.
Tuesday is, Wednesday it's possible.
Wednesday.
Yes, I will be back.
What will be the date? 30. 30.
Yes,
Lordship.
Lordship.
Much obliged.
Oblige, Your Lordship.
May I please, your Lordship? Your Lordship, item number. Yes, 12, 13 and 14, it's, yes, analog. Yes, Your Lordship.
12, 13 and 14.
Yes, Your Lordship.
Arising out of same FIR, madam.
Rising out of save.
Yes, madam.
In fact, we have budgeted before the IO and reported our statement also. And more so, Lordship, we have entered into an amicable settlement also. It's a minor scuffle between the clan sisters. In fact, we have filed a criminal petition also today. It will be coming on list tomorrow.
You were on interim bail.
Yes.
We are protected already.
They were directed to appear before the IO for recording of their statement.
They have appealed.
Yes, my lord, they have appeared, but today I have not received the entire CDL. It's a status report, but it revealed everything, your lordship. They
Their
appeared,
statements are available or not?
your statement, your lordship, their statement has not been given yet. Only,
Select the case diary for updating the same.
yes, your lordship.
Hard MS.
Etalo.
Appealing for, your Saxena is also appealing.
Yes, item number 13.
In item number 13, case Saxena. In item number 11, MS so and so. Item number 12.
12 and 14, Your Lordship.
12,
And 14.
12 and 14, you are. The 12, 13, 14, you make a common order. You write, this is a common order for these three items. Hard MS so and so. And Mr. K. Saxena, appearing for the petitioners. Pursuant to the interim order granted in favor of the petitioners, they have appeared before the investigating officer and their statements are accorded. Mr. T. Ete, the learned additional public prosecutor submits that in that case, the CD needs to be updated. Therefore, CD which he has received today shall be returned for updating the same. Give it a list again on next Monday. It will come or not? Next Monday?
Only for Itanagar.
Eternal.
Maybe my lord on 29 then.
On 29. Till then, the interim order past shall continue in all the three items.
Deeply obliged.
None appears for the petition on call. Since the office note dated 21/07/2025. Await for the service report in respect of the sole respondent. List after 3 weeks.
Lordship.
Yes.
Lordship, yesterday, my lord has quashed the matter in favor of mother. Today, it is the son. Same complaint, same issue, same complainant.
Oh.
Today, the mother is the joint petitioner. Oh, yes, son is the joint petitioner. Yesterday, it was mother.
They have compromised.
Yes, already. Settlement is at page number 100 and 104. Lordship has already passed yesterday in favor of son.
Yesterday's case was son.
Yes, today's mother.
And today's mother.
Yesterday's mother, today's son.
But today is son. Okay, Mr. I think.
Yes, yes, ma'am. All right.
Yes.
Your Lordship. Here in this case, Your Lordship, we have to take fresh steps, Your Lordship, because now we are being informed that the address of the respondent has been changed. So direction may be given to take fresh steps to new address.
To all the respondents.
Yes, yes.
Yeah, only for respondent number 6 probably.
Yes, yes, only for private
For
schools.
1 to 5, I'm appearing, madam.
You are from 1 to 5.
Yes, ma'am.
Heard Mr. So-and-so appearing for the petitioner. Heard MS so-and-so appearing for the respondents 1 to 5. The learned government advocate
Yes, ma'am.
appearing for the senior or junior.
Yes, madam.
Senior, junior,
Junior, madam.
junior governors appearing for the respondents 1 to 5. The petitioner is directed to take fresh steps for service of notice upon the respondent number 6
Yes.
by registered postal ID. Least after 4 weeks.
Okay.
Yes.
Your Lordship, with due respect, Your Lordship, there is an interim order. Interim order is there. Kindly note that.
Continue. Yes.
May it pleases your lordship. My lord, this is a revision against an order passed by the learned session judge UPIA, whereby the learned session judge has upheld the order of conviction passed by the learned magistrate court under section 138 of the Negotiable Instrument Act. My lord, the case in short is that the allegation is that the petitioner have issued a check of 5.72 crore, 5 crore 72 lakhs. And the check got dishonored, and therefore this case. My lord, to bring home the guilt, my lord, the complainant, they have examined 3 witnesses. Witness number 1 is the complainant himself, and there are other 2 witnesses, and I will demonstrate during the course of my argument that these 2 witnesses in fact damages the case of the prosecution. My lord, both the court below have proceeded on the premise primarily that there is a presumption under 139 of the Negotiable Instrument Act. Now that presumption was not rebutted by a direct evidence. Now, my lord, in my respectful submission, a accused even need not enter into a witness box in order to rebut that presumption. That presumption, my lord, can be rebutted in 4 different modes. One of them is direct evidence. The other is by relying on the evidence led by the complainant. The third is by relying on presumption of law. In other words, suppose there are certain documents in their possession which they have withheld. In that case, your lordship is aware, an adverse presumption is taken under 114 Evidence Act. By that presumption also, this 139 presumption can be rebutted, and it can also be rebutted based on the circumstance. So the learned court below have fundamentally erred by holding that since he has not led direct evidence. Now, my lord, there is a paper book. I'm sure there is a paper book, my lord. My lord, I'll start with the complaint petition and then only 3 witnesses, not much, my lord. My lord will find the complaint petition at page number 2. It starts, the operative part, it starts from page 2.
Yes.
Now, my lord, the complainant is the proprietor of Messrs. MY Enterprise. The complainant knows the accused as they belong to the same area, and he is the proprietor of Messrs. Tanga Enterprise. Now, my lord, the allegation is against Messrs. Tanga Enterprise. Tanga Enterprise is not a party.
Not a party.
Not a party. They have made only the proprietor a party. I'll show your lordship from a recent judgment of this court that they ought to have made Tanga Enterprise as an accused number one. That on 28th February 2018, a deed of agreement was made in between the complainant and the accused, whereby the accused acknowledges his taking of loan of rupees 5,72,000, 5 crore 72 lakhs from the complainant and return the loan amount through check bearing number such and such, office farm account number such and such, maintained with the Allahabad Bank Itanagar branch such and such, in favor of the complainant, with condition that the same shall be withdrawn by 15th of April 2018. The accused put affixed his signature on the check. So what they essentially say, that there is an agreement between the parties, and in that agreement, the accused acknowledges the depth of 5 crore 72 lakhs. My lord, may kindly come to page 23. That is the agreement which they are relying on. Page 23.
Yes.
This deed of agreement is made on this day on 28th February 2018 at Nahar Lagoon between such and such and such and such. Now, therefore, these are the details of the parties. I'll just skip. Now, this deed witness as follows: that the first party, Messrs. Tanga Enterprise, proprietor such and such, receives a loan from second party, Messrs. Such and such. And now, first party paid his loan amount by a check number, account number, such and such, that the check received by the second party as his refund amount of the loan should be withdrawn in the month of April 2018. Next page. That if at the time of withdrawal of the check by the second party found any wrong or bounce, that check should be liable by first party to the second party, and at that time, second party can claim for suit a case against, my lord, these are all legal. My lord, I could not find even a single rupee. Where is the acknowledgement of 5 crore 72 lakhs? Not a single amount is mentioned here. And in the petition, this astronomical figure of 5.72, 5 crore 72 lakhs, there is no amount. So therefore, my lord, the basis of the complaint petition at page number 2, again reverting back to page number 2, it is an incorrect statement, taking a loan of such and such by executing an agreement. Para 3, that on 16/4/2018, when the complainant went to the bank to withdraw the check in pursuance to agreement dated such and such, the accused telephonically requested the complainant not to deposit the check and assured her to withdraw the amount by 2nd week of July 2018. 4, it is further submitted that the complainant deposited the above check on such and such in her farm account such and such, maintained with Bank of India Itanagar branch, which is in its validity period. Number 5, it is submitted that subsequently the Bank of India presented the same check at Allahabad Bank Itanagar branch and was dishonored due to funds insufficient, and was intimated to the complainant on such and such by return memo dated such and such issued by the Allahabad Bank Itanagar branch. Number 6, it is submitted that the complainant verbally intimated the accused above the dishonored of check issued by him on several occasions, but he failed to deposit sufficient money. Therefore, on such and such, the complainant has causes to issue a notice through her lawyer by registered post, 15 days. I'll skip all this. 7, it is also submitted that notice dated such and such was caused by registered post in the correct address on such and such, and the said notice was delivered to the accused on such and such. And my lord, next page number 4 is the common statement, that 138 is a common statement. Now, PW1, that is the complainant herself. Page number 7. This is the evidence evidence on affidavit, that is in chief. That I am the complainant of the instant case and would like to place the following evidence in support of my complainant in the form of an affidavit. That the accused is executing a PMGSY road from so-and-so to so-and-so, the attorney holder of Messrs. Him Enterprise in joint venture with Messrs. Such and such. The total cost of the project is about rupees 40 crore. That my husband, Sri so-and-so, and accused are known to each other. So the accused approached him to extend some loan for carrying out the said road project. Accordingly, my husband convinced me, my lord will kindly take note of this. Husband is convincing her to give a sum of rupees so-and-so to the accused. On 28/2/2018, the accused signed an agreement acknowledging of his taking loan money from the complainant. I've just now shown the agreement. There is no money. Number 4, that as per the agreement dated so-and-so, accused issued a check bearing number such and such from his account such and such maintained with such and such to Messrs. MY Enterprise. MY Enterprise is the complainant side. With condition that check amount has to be withdrawn by 15/4/2018. That while the complainant was about to present the said check to the bank on so-and-so, requested to deposit a check by 2nd week of July. My lord, these are reiteration of what was there in the complaint petition, that it was deposited, it was dishonored, that sort of. Just there is one additional fact which your lordship will find at page number 9, paragraph 8. That the notice was sent to the accused through registered post on such and such from Naharlagun post office, and the same was delivered to the accused address on such and such. That even it is written event, it should be even. That even after receipt of said notice, the accused ignored to pay the check amount to my husband, engaged by Yumlam Radhe to negotiate with the accused for immediate return of the check amount. The accused, instead of return the check amount, handed over a sum of rupees 1 crore to such and such for being partial discharge of liability, but the same was not accepted by me and my husband. Thus, I filed this complaint. So, my lord, she says that the accused, through this gentleman, that is PW3, Yamlam Radhe, had given 1 lakh to negotiate, but they have not accepted. That is what it is said. Now, my lord, this Yamram Radhe is PW3. I will show from the evidence of PW3 whether they have accepted or not. My lord will just keep this, my lord will just mark this, that they are saying that he has not accepted it. Rest, my lord, are the accused intentionally drew a check. That's the common paragraphs, my lord. I ignore. Now, my lord, what will raise your lordship's eyebrow is the cross-examination part at page number 11. My lord, this I'll read little slowly. I'll read this, my lord. My lord, the amount is 5 crore 72. Now, she comes up with completely different story and different figures. I have completed my post-graduation and presently I am attending coaching for civil service. Presently, I am unemployed. 5 crore 72, husband convinced her she is unemployed. It is a fact that there is no mention of any amount in the deed of agreement dated such and such exhibited between the parties and me. So they admitted that there is no amount in the agreement. Accused has taken rupees 7 crore 72 lakhs. Suddenly, it increased to 7 crore now. The said amount also includes the value of vehicle like excavator, forklift, and other vehicle, which I do not remember right now. Separate version, that as if the loan incurred because of he has taken some vehicles, but no detail of vehicle is given. I am the registered owner of the said excavator and forklift, and regarding other vehicle, I cannot say if I am the registered owner or not. I do not remember the registration number of excavator and forklift. I cannot say if I can produce the registration certificate of the said vehicle. Accused purchased my vehicle, but I do not remember the number of vehicle purchased by him. Such and such, that is the name of the accused, did not pay the cost of the vehicle. So, my lord, whether it is loan or it is cost of the vehicle, I have executed a sale agreement of the vehicle. I do not remember the date when the sale agreement was executed between the accused and me. Right now, I cannot say what was the amount taken by the accused and the value of the vehicle, but the value of the vehicle can be ascertained by the agreement entered between the me and the accused, which I can produce. Right now, I do not have the agreement. So, my lord, just I take a pause. Here she said, right now, I cannot say what was the amount taken by the accused. First, she said in chief 5,72,000. Then in the starting of the cross, she said 772. And now she is saying that I don't remember how much money he has taken. Then he says that the amount is written in some agreement, but he has not produced it. And he said he can produce, but she has not produced it. Right now, I do not have the agreement. Accused has taken loan from me on several occasions and agreement has been executed. But I have not produced the other agreement in the present case. I only produced the agreement dated such and such, which is the agreement of total amount taken by the accused. So therefore, my lord, on the date when this agreement was signed, no such amount was taken by her. It is some accumulation of some vehicle, what she is saying, and without any detail, without any evidence, she is saying that. On the date of the agreement, that is 28/2/18, the accused has given me a check of so and so as security. The loan was given to accused through check and on cash. The check was issued either in the name of such and such and either in the name of Lokham Talo and Messrs. Tanga Enterprise, of which Lokham Talo is the proprietor. I do not remember how many check has been issued to Lokham Talo and Tanga Enterprise and also the total amount. It is a fact that my husband, such and such, and accused have executed PMGSY scheme between such and such and such and such. So my lord, he says now that some money I have given him through cash, some through check. She doesn't say how much through cash she has given, how much through check she has given. She's also not sure whether the check was issued in the name of the proprietor or the check was issued in the name of the firm. I have no idea if, yes, accused has requested to invest. Yes, now that's, it is a fact that my husband, so-and-so and accused have executed PMGSY scheme between so-and-so to so-and-so. Accused has requested us to invest in the said project and to repay the amount with interest up to such and such. I have no idea if my husband such and such has deposited the EMD money. Now this is the another new story. Now she says, first she said loan, then she says it is the value of the vehicle. Now she says that he has invested, my husband has invested in some project and the loan incurred because of that project. Accused has requested us to invest in the said project and to repay the amount with interest up to April such and such. I have no idea if my husband such and such had deposited EMD of such and such for the aforesaid work under such and such. The witness in the agreement dated such and such are so-and-so, so-and-so, and so-and-so. I do not remember where the agreement was executed. Even that is, she doesn't remember. It is not a fact that the accused is to keep signed non-judicial paper with my husband. It is not a fact that the accused is to keep his check with my husband, such and such. It is not a fact that the check in the present case has been misplaced by the accused person. I do not remember whether accused person has given information on such and such to the police regarding the missing of the check in the present case. It is a fact that as per letter dated 24/7/18, the manager of Allahabad Itanagar branch has stated the check in question has been returned with reason fund insufficient, whereas the reason ought to have been check stopped by drawer. My lord, this is a very important suggestion. She is admitting that there is a letter from the bank where the bank has clarified her that it is not due to insufficient fund. The reason which we have given, that insufficient fund, it is not insufficient fund. It is because check stopped by drawer. She is admitting that there was a letter. I looked after the accounts of my husband. The amount taken by the accused are of my husband. Now, my lord, initially, if your lordship remembers, she said husband convinced her. Now, my lord, now she is saying that the amount taken is the husband. It is not a fact that my husband could not file the present case. It is not a fact that Lokham Talo has not taken any money from me. It is a fact that I have not produced all agreement of loan taken by the accused. My lord, also take note of this. She is admitting it is a fact that I have not produced all agreement for the loan taken by the accused. The check was dishonored on such and such and returned on the same day. The check is of such and such. I have presented the check only once. After the check was dishonored, I served a demand notice. It is not a fact. Now, my lord, the husband here, the name of the husband appeared so many times in the evidence as well as cross-examination. My lord, what a prosecution was expected to examine the husband. She was a very vital witness. Conspicuously, the husband is not a witness to this case. Now, this is, now the second witness. That I know the complainant and the accused as they are from the same district. That on such and such, I was one of the witness in the deed of agreement between the complainant and the accused. That during the time of agreement, I saw accused handing over a check of such and such to the complainant, and accused also verbally asked her to withdraw the money by such and such. Here he is saying that he has seen PW2. The complainant informed me the check issued by the accused has dishonor on being presented to the bank. This is his in chief. Now kindly see his cross, page number 15, because he has seen that he said that he has seen the execution of the agreement and handing over of check. She says, I have done MA in political science. In the agreement dated 28/2/2018, it is only mentioned that the loan has been taken by accused, but no amount has been given. It is not a fact that the accused stated while giving the check that there was no amount in the account against which the check was issued. I cannot say if there was amount in the account of such and such. Accused, while giving the check, told the complainant to present the check on 15th April 2018. The check was issued on the same day when the agreement dated such and such was executed. The agreement was drafted at the house of the complainant such and such. It is a fact that during the execution of the agreement, Lokham Talo was not present there, but his wife was present. Now, my lord, she is self-contradicting. Lokham Talo is the accused. He says he has seen Lokham Talo handing over the check. He says the agreement and the check, that transaction was done on the same day. Now he says at the time of this agreement, Lokham Talo was not there. Rather, wife was there. I do not know about the transaction between Lokham Talo and such. I was told that the check was issued regarding PMGSY scheme. It is not any loan. Some check, some PMGSY scheme. I do not know the monetary transaction between complainant and accused. Apart from issuing check by the accused to the court, I do not know anything. I do not know that the check lost from the possession of the local. This is what is the evidence. Now, there was a re-examination done of this witness. It is a fact that during the registration of the agreement before the magistrate, both the parties has to be present. I was present when the agreement was registered at Naharlagun before the executive magistrate. Lokham Talo himself has put the signature in the agreement before the executive magistrate. Now, cross on the re part. Yamlam Radhe was present when the agreement was registered before executive magistrate. Now, this man, this PW2 says that one Yamlam Radhe was present at the time of when the agreement was executed. My lord, I will straight away take your lordship to the deposition of this Yumlam Radhe. Kindly turn to page number 19, last line.
Yes.
Last line. I do not know about the agreement dated 28/2/2008. I'll come to his evidence later. Just I have shown that this PW2, this witness has no credibility because he is self-contradicting himself. Once he says it was done on the same day, on the same breath, he is saying, no, he was not present, his wife was present. Then he says present at the time of registration along with one Yamram Radhe PW3. PW3 says, I do not know anything, forget about being present or absent. Now the last, that is PW3, page number 70. I know both the complainant and the accused for last many years that the complainant and her husband such and such requested me to negotiate the accused for immediate returning of the loan amount, and the check issued by him has been bounced. I went to the house of the accused and discussed him about the matter, wherein he fairly admitted of taking money from the complainant and issuing a check in her farm name from the account number, his farm, where there was no sufficient fund. Accused handed over me a sum of rupees 1 crore to give to the complainant as part payment of rupees such and such, and requested me to convince the complainant and her husband to accept the same and to take the remaining amount afterward. But the complainant refused to accept the said rupee 1 crore, stating that she wants whole amount at one go and she and her husband cannot bear with the lie of the accused anymore. Now rupees 1 crore is lying with me. Now kindly turn to page number 19, the cross part. I know Lokham Talo and such since long time. I know the complainant, namely so-and-so. She is the wife of so-and-so. So-and-so has requested me to negotiate with Lokam Talo regarding the monetary transaction in connection with contract executed under PMGSY scheme for construction of road between so-and-so to so-and-so. It is a fact that so-and-so and so-and-so have agreed to execute the contract work under PMGSY scheme for construction of road. In this regard, so-and-so has deposited 1.20 crore as EMD. The present case is arose from the contract work under PMGSY scheme. I have not seen Lokam Talo taking money from such and such, but my lord, he has not seen taking money. I have not seen Lokam Talo taking money from such and such, but I was told that money has been taken by Lokam Talo. I do not have any idea how much money has been taken by Lokam Talo from the complainant. I have witnessed that Lokam Talo has repaid an amount of rupees 1 crore to Bage Yama. I do not know about the agreement dated such and such. Now he says that I have witnessed that he has repaid the 1 crore. She has witnessed. Now he's saying. So these are the evidentiary. These are the. Then the agreement also, your lordship, I have taken your lordship to the agreement that is at page number 23. And the check in question is at page number 25. It is signed by, my lord will see, the check was given to an MOI enterprise by Messrs. Tanga Enterprise. The proprietor of Tanga Enterprise is there. Now, my lord, this is the bare facts of the case, my lord.
Tanga Enterprise not made a party.
Tanga Enterprise is not a party. I'll demonstrate, my lord, on that very count itself. Very recently, in this particular Itanagar bench, my lord, this honorable court have dismissed, has allowed the criminal revision by setting aside judgment of both the court below on this very count itself. I'll show that judgment is by Justice Pupon. Now, these are, my lord, I have highlighted the particular paragraphs. My lord, just before your lordship turn into that compilation, my lord, now through these judgments, my lord, what I am trying to impress on this honorable court are these. My lord, now here is a case, my lord, your lordship is aware that there is a presumption in their favor under 139. The issue is, how a accused can rebut, whether it is necessary for the accused to lead direct evidence, whether that is the only mode of rebuttal. My lord, in my respectful submission, that is not the only mode of rebuttal. By showing this judgment, I'll indicate that the law is clear. Even the accused need not step into the witness box. He can absolutely rely on the evidence tendered by the complainant. This is one way, by relying on there. Another way of rebutting the presumption is through presumption of law under 140. Suppose certain documents, in this case, vehicle agreement, all documents, he says there were several agreements, those agreements withhold, they say it was a consideration flowed due to some purchase of vehicle agreement, these things. So since they have not adduced this thing, my submission is there is a adverse presumption that can be drawn. Since the husband was not made a witness, one of the star witness would have been the husband. So withholding a witness also draws an adverse presumption. Your lordship knows, my lord. So through these adverse presumption, even that presumption can be rebutted, because the burden on me is preponderance of probability. The burden on them is beyond reasonable doubt. That never shifts. So, my lord, may kindly turn to page number. This is the first judgment. Kundan Lal, this is 3-judge bench judgment. My lord, I have highlighted the portions which I am relying on. Page number 3. My lord, may kindly turn to page number 3. My lord, we'll see the highlighted portions, my lord. I'll not bother your lordship with the entire this. The question, and this is a 3-judge bench judgment. The question is how the burden can be discharged. The burden under 139. One, the burden of proof as a matter of law and pleading, and the other is the burden of establishing a case. The former is fixed as a question of law on the basis of the pleading and is unchanged during the entire trial, where the later is not constant but shift as soon as the party adduces sufficient evidence. The evidence required to, now this is important, madam. The evidence required to shift the burden need not necessarily be direct. Need not necessarily be direct. That is oral or documentary evidence or admission by the opposite party. It may comprise circumstantial evidence or presumption of law or fact. Next, the defendant may adduce direct evidence to prove that the promissory note was not supported by consideration. And if he adduce acceptable evidence, the burden again shift to the plaintiff and so on. The defendant may also rely upon circumstantial evidence. And if the circumstances so relied upon are compelling, the burden may likewise shift again to the plaintiff. He may also rely upon presumption of fact, for instance, those mentioned in 114 and other section of the Evidence Act. Under section 114 of the Evidence Act, the court may presume the existence of any fact which it thinks likely to have happened regarding, my lord, I skip that quotation part, my lord, may kindly come to the last part which starts with, my lord, I'll read this. No, okay, my lord, it will not take much time, I'll just complete it. The court may presume the existence of any fact which it thinks likely to have happened regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. Private business in their relation to the facts of the particular illustration G to that section shows that the court may presume that the evidence which could not be and is not produced could, if produced, be unfavorable to the person who holds it. The evidence which could be produced and is not produced, the court will presume that if it is produced, if the husband was examined, if the agreement would have been produced before this court, all previous agreements, if the vehicle agreement would have been produced before the court, then the court, it would have clarified the position. Now, once they are not producing this, then the law says that the court will presume that if you adduce all this evidence, it will go against you. A plaintiff who says that he had sold certain goods to the defendant and that a promissory note was executed as a consideration for the goods and that he is in possession of the relevant account book to show that he was in possession of the good sold and that the sale was effected for a particular consideration should produce the said account books. For he is in possession of the same and the defendant certainly cannot be expected to produce his document. In those circumstances, if such a relevant evidence is withheld by the plaintiff, section 114 enables the court to draw a presumption to the effect that if produced, the said account would be unfavorable to the plaintiff. This presumption, if raised by a court, can under certain circumstances rebut the presumption of law raised under 118 of the Negotiable Instrument Act. Now, this is the summary. Briefly stated, the burden of proof may be shifted by presumption of law or fact, and presumption of law or presumption of fact may be rebutted not only by direct or circumstantial evidence, but also by presumption of law or fact. We are not concerned here with the irrebuttable presumption of that a presumption under 138 that if they have a check, it will be presumed that I have issued it. This presumption can be rebutted by presumption of law. If they withhold certain document, then the court will, the court will invoke a presumption under 114 that if you would have adduced those evidence, it would go against you, and therefore you have withhold. And this presumption will rebut the presumption under 113, and that is what the 3-judge bench of the Supreme Court way back in 1961 have held. Now, kindly turn to page number 18 of this compilation. The page 18.
Yes.
My lord will see the highlighted portion. For rebutting such, my lord, here such presumption is means that presumption under the NI Act. Because both the court below has proceeded that I have not adduced any, that is a different story, my lord, why I could not adduce evidence. That since I have not adduced any direct evidence, therefore my case should go because there is a presumption under 139. Now, on that context, my lord, this is for rebutting such presumption, what is needed is to raise a probable defense. Even for the said purpose, the evidence adduced on behalf of the complainant could be relied upon. So, evidence adduced by the complainant can be relied upon for rebutting that presumption. And I am relying upon their evidence. Then the next. The defendant of proving the non-existence of the consideration can be either direct or by bringing on record the preponderance of probability by reference to the circumstance upon which he relies. In such an event, the plaintiff is entitled under the law to rely upon all the evidence led in this case, including that of the plaintiff as well. In case where the defendant fails to discharge the initial onus of proof by showing the non-existence of the consideration, the plaintiff would invariably be entitled to the benefit of presumption arising under 118A in favor. The court may, now this is important, the court may not insist upon the defendant to disprove the existence of consideration by leading direct evidence, as the existence of negative evidence is neither possible. So the Supreme Court give a caution that court should not insist accused to lead direct evidence to rebut. Next, this court therefore, this is the sum and summary of this judgment, my lord, this line. This court therefore clearly opined that it is not necessary for the defendant to disprove the existence of consideration by way of direct evidence. Direct evidence not required. The standard of proof evidently is preponderance of probability. Inference of preponderance of probability can be drawn not only from the material on record, but also by reference to the circumstance upon which he relies. Now here, my lord will see the circumstances. A civil service aspirant who deposes that she is unemployed is lending an amount of 5 point such and such crore. Is this circumstance inspires confidence, my lord? She says, husband convinced, then say husband's money. Then somewhere she says, actually here the accused has taken so many vehicles, excavators, such and such. Vehicle number, do not know. Agreement there, I will not produce. Then she says, suddenly 5.72 became 7 point something. Then on the same breath, she says, I don't remember how much loan he has taken. So on those, my lord, this. Now, my lord, may kindly turn to page number 38.
Of this compilation.
Yes, this. I'll just read. My lord, page 38. Para number 28. In the absence of compelling justification, reverse honors clause usually impose an evidentiary burden and not a persuasive burden. Keeping this in view, it is a settled position that when an accused has to rebut presumption under 139, the standard of proof for doing so is that of preponderance of probabilities. Therefore, if the accused is able to raise a probable defense which creates doubt about the existence of a legally enforceable debt or liability, the prosecution can fail. As clarified in the citation, the accused can rely on the material submitted by the complainant in order to raise such a defense, and it is conceivable that in some cases the accused may not need to adduce evidence of his own or her. He may not need to adduce any evidence of him or her showing his innocence. He can rely on the material submitted by the prosecution, just like other criminal cases, my lord. Now, my lord, may I kindly turn to page number 42. Para number?
Yes.
9. Now, it has to be stated in order to draw the presumption under section 118 read with section 139 of the NI Act. The burden was heavily upon the complainant to have shown that he had the required funds for having advanced the money to the accused, that the issuance of the check in support of the said payment advanced was true, and that the accused was bound to make the payment as has been agreed while issuing the check in favor of the complainant. The Supreme Court says it is incumbent on them to show that they have the, to show to the court that they have the requisite fund to advance as a loan. It is incumbent. Subsequently, Supreme Court have diluted it to some extent. Supreme Court said that in cases where financial capacity is questioned, in those cases, it is bound. Here we have questioned the financial capacity. We said, what do you do? He said, I am a student. She said, I am an unemployed. So her financial capacity was questioned in this case. And therefore, it was incumbent. There is, my lord, it does not, she is contradicting herself. 5.72, husband has to convince her. And then next para say, I am unemployed. Then para 11 of that. We find that the various defects in the evidence of the respondent, as noted by the trial court, which we have set out in para 6 of the judgment, were simply brushed aside by the High Court while assigning any valid reason, without assigning any valid reason. Such a serious lacuna in the evidence of the complainant, which strikes at the root of the complainant under complaint under 138, having been noted by the learned trial court, which factor was failed to be examined by the High Court while reversing the judgment of the trial court, in our consistent opinion, would vitiate that. My lord, my purpose of relying on paragraph 11 is to show then where there are inherent defects in the evidence of the complainant, in those cases, the prosecution is bound to fail. Then this is 43. My lord, may kindly come to page 53. Para 34. These are all NI Act cases, my lord. These are no IPC. I have not relied on a single IPC cases or other cases.
Para 34.
34. I think it is marked, my lord. Yes, yes. Furthermore, where prosecution must prove the guilt of an accused beyond all reasonable doubt, the standard of proof so as to prove a defense on the part of an accused is preponderance of probability. Inference of preponderance of probability can be drawn not only from the materials brought on record by the parties, but also by reference to the circumstance upon which he relies. A statutory presumption has an evidentiary value. The question as to whether the presumption, whether stood rebutted or not, must therefore be determined keeping in view the other evidence on record. For the said purpose, my lord, kindly, this is very important, my lord. For the said purpose, stepping into the witness box by the appellant is not imperative. In a case of this nature, where the chances of false implication cannot be ruled out, the background fact and the conduct of the parties, together with the legal requirement, are required to be taken into consideration. So my stepping into witness box is not required, my lord. My lord, this para 39, this is also more or less on the same line. I'll skip. Yes, now this is, my lord, NI Act, what the Supreme Court is saying, page 55, paragraph 44. Even the Supreme Court is talking of the human rights and the presumption. Page para 44, NI Act is. The para 44 is page 55. The presumption of innocence is a human right. These are the judgments. Article 6.2 of the European Convention on Human Rights provides everyone charged with a criminal offense shall be presumed innocent unless proved guilty according to law. Although India is not bound by the aforementioned convention, and as such it may not be necessary, like the countries forming European countries, to bring common law into land with the convention, a balancing of the accused right and the interest of the society is required to be taken into. In India, however, subject to the statutory interdicts, the said principle from the basic of criminal jurisprudence. For aforementioned purpose, the nature of the offense, seriousness, as also gravity thereof may be taken into consideration. The court must be on guard to see that merely on the application of presumption, this is my lord, the court must be on guard to see that merely on the application of presumption as contemplated under 139 of the Negotiable Instrument Act, the same may not lead to injustice or mistaken conviction. That only there is a presumption that should not lead to conviction. It is it is for the aforementioned reason that we have taken into consideration the decision operating in the field where the difficulty of proving a negative has always been emphasized. It is not suggested that a negative can be proved, but there are cases where such difficulties are faced by the accused. Examples are. My lord, what is the idea behind? So far I could understand that it is the negative is very difficult to prove. Suppose I say that you have done it. Now, I have not done it. It is very difficult because he'll have to prove negative. It is very difficult.
Yes.
That is the precise reason your lordship will remember why the IMDT Act was repealed. Because there the burden was on the state to prove that he is not a citizen. So that was repealed. He said it is difficult to prove negative. This is gone. Date of loan. Now, one judgment where similarly date of loan, suggestion of issuing blank check was there, financial capacity was questioned, not explained, and ultimately acquitted. It is page 62.
Yes.
Para 6, my lord will see, I have just highlighted one line. Neither in the complaint nor in the examination chief has the complainant stated the date of giving the loan to the accused. Here also there is multiple dates. What is date of execution of the agreement is given, but when the loan incurred, that is not given. Neither. This is one fact. Then kindly turn to page 63. In between I have highlighted. Further on the question whether the accused received 15 lakhs from the said transaction, he showed his ignorance. Suggestion was also put that the blank check was issued at the time of availing such and such. Suggestion was also put in his cross-examination that he was not having such and such. In my case also suggestions were put that the check was lost. Suggestions were, my purpose of relying on this para is to show that Supreme Court has even taken suggestions into account. Now, my lord, may kindly come to page 74.
Yes.
Page 72, my lord. Page 72.
Yes.
These are the summaries. 25.3, 25.4, and 25.5, my lord, may kindly mark these three paragraphs. This will sum up. To rebut the presumption, it is open for the accused to rely on evidence led by him, or the accused can also rely on the material submitted by the complainant in order to raise a probable defense. Inference of preponderance of probability can be drawn not only from the material brought on record by the parties, but also by reference to the circumstance upon which they rely. 25.4, directly on the point, that it is not necessary for the accused to come in the witness box in support of his defense. Section 139 imposes an evidentiary burden and not a persuasive burden. 25.5, it is not necessary for the accused to come in witness box to support his defense. It is not necessary. That means I'll have to rebut by leading direct evidence. This is gone, my lord. 74. Yes, that is the financial capacity, my lord may see 74 page number. Financial capacity being questioned, it was incumbent on the complainant to have explained his financial capacity. Court cannot insist on a person to lead negative evidence. This is not 74 form. Page 79, my lord, for a while. My lord, these are more or less same sort of judgment, my lord. I will not repeat the same, that he need not lead evidence. He can rely on the court unless the High Court came to find financial capacity. This is financial capacity. Income tax return was not filed. In this present case, my lord, even bank statements were not file to show that, because my lord, she says that some cash, some check. She doesn't remember how much cash, how much check. Now, if she has given loan by check, the bank statement would have been the best piece of evidence. This I'll skip, my lord. These are more or less same. 90, then 190, okay, so 95, 95. Yes, my lord, in the page 95, my lord may turn. Here also under the NI Act also, my lord, if two views are possible, the view page 95, my lord, para 5. To say the least, the approach of the High Court is totally fallacious. In an appeal against conviction, the appellate court has the duty to itself appreciate the evidence on the record. And if two views are possible on the appraisal of evidence, the benefit of reasonable doubt has to be given to an accused. Then the next, an appellate court may give every reasonable weight to the conclusion arrived at by the trial court, but it must be remembered that an appellate court is duty bound in the same way as the trial court to test the evidence extensively as well as intrinsically, and to consider as thoroughly as the trial court all the circumstances available on the record so as to arrive at an independent finding regarding guilt of innocence of the convict. An appellate court fails in discharge of one of his essential duties if it fails to itself appreciate the evidence of the record and arrive at an independent finding based on the appraisal of such evidence. But here I take a pause. Why I have relied on this judgment? The appellate court, that is the learned session court, UPA, my lord, she has not dealt with the evidence independently. She has completely relied on the appreciation of evidence by the trial court. Your lordship has also, my lord, passed so many judgments in the appellate side. When an appeal is placed, the appellate court, we have seen, my lord, our experience was that the appellate court, they discuss the judgment independent of what the trial court has. Now, in this case, the entire the appellate court has dependent on the appreciation. There is no appreciation of evidence by the appellate court, independent of the trial court appreciation. She says, trial court have correctly held, trial court have correctly held. Now, my lord, on the point that the farm is not a party. The accused is a party. Whether a prosecution under NI Act will sustain. My lord, may kindly turn to page number 110. This is Itanagar bench judgment, my lord, 2020. Para 20, somewhere in between, my lord. The present petitioner is the proprietor of the said farm, and he is liable vigorously only. Without arraying the farm as an accused, the petitioner cannot be prosecuted for the offense committed by the farm. This was one of the ground where ultimately para 112, page 112, para 22, he was acquitted. Both the judgment, para 22, 112, both the judgments were set aside. That you cannot, relying on some of the judgments of the Supreme Court, this honorable court, a single bench of this honorable court have held that you cannot, the present petitioner of that case is the proprietor of the said farm, and he is liable vigorously only. Without airing the farm as an accused, the petitioner cannot be prosecuted for the offense committed by the farm. Now, the farm, yes, NI. That is NI. All judgments are, sir, NI. Now, my lord. Now, my lord, on the last occasion, because this matter was also heard by Justice Mridul Kolita. So on that day, his lordship asked certain questions to me. So I have formulated a written argument based on the queries of that court. But on the next day, he was not available. So this is the handwriting of his lordship only. That with that, this is I'd like to rely on this. Because these are certain questions he asked me. I just made a small written argument, more or less. मेरा तो काम है। आपको दे देता है, अभी दे देता है, एक सेकंड मेरा तो नहीं। Yes. Now, my lord, a query whether under a revision the court can set aside the judgment or court can remand. Then I made a submission that it can be set aside. These are the judgment. Then he said, then the question was, what is the power of a revisionary court under 397? This is a judgment. I have quoted from the judgment 2012. I can give copies of those judgment. Your lordship may cross-verify. This is quoted from the when the decision under challenge is grossly erroneous, there is no compliance with the provisions of law. The finding record is based on no evidence. Material evidence is ignored, or judicial decision is exercised arbitrarily or perversely. Then what is perversity? One judgment I have quoted from the particular paragraph or one judgment. If it outrageously defies logic, in this case also it defies logic how an unemployed lady can give a loan. And if it is irrational, then evidence is thoroughly unreliable because the evidences are unreliable. PW2 one says that I have seen check, then he says no. She names one more, PW3 to be present. PW3 says forget about presence, absence. I do not know anything about that agreement. So these are the ground. Now the inconsistencies in the evidence, my lord, I have just, this is my, that PW1 is unemployed and doing coaching for civil service. So when financial capacity, she could not give any answer. PW1 failed to mention the date of loan. If such a huge amount, anyone would remember the date, amount not mentioned in agreement. PW1 does not remember where the agreement was executed. Very unlikely. PW1 in chief said husband convinced her to pay 5.40 in cross version 7.72 on installment basis. How it increased miraculously, how multiple payments. PW1 in chief said husband convinced her to pay, but in cross she says the amount taken belongs to her husband. Now husband not made a witness. 3 modes of incurring liability. From the agreement, there are 3 modes. From the evidence, there are 3 modes. In chief, entire amount was a loan amount as husband convinced her to pay. In cross, amount includes value of excavator, forklift and other vehicle. Petitioner purchased vehicle but did not pay the cost. Third, husband of PW1 made investment in business of the petitioner and the petitioner was to return with interest, inherently inconsistent regarding how the petitioner acquired the liability. There is no consistency. In cross, she could not say what was the amount taken by the petitioner. That is most damaging. Vehicle sale deed executed but not exhibited. Does not remember the date of execution of vehicle sale deed. Many loan agreement but did not exhibit. Money belonged to husband but husband not examined. Loan advanced by check and cash but did not exhibit bank statement to show check payment. Adverse inference under 114 illustration G. For total amount there is an agreement but that agreement does not mention amount. So there is an adverse presumption under this. For total amount there is an agreement. They say there is an agreement but the agreement does not mention any amount. She says loan was paid by check and cash, but does not know how much paid in cash, how much paid in check. In fact, she is even not sure whether the check was issued in the name of the petitioner or his firm. Then the witnesses who have the witnesses, my lord, already I have made, they are self-contradictory. They have made self-contradictory statements, my lord, for the witnesses. My lord, this is what I have to submit, my lord, subject to.
Yes. Yeah, for a respondent. Yes, I am for
complainant. It is
complainant. Complainant. Well, before I come to reply, my friends, let me take my laws to section 130 of Negotiable Instrument Act. What the Act says. May I read? Dishonor of check for insufficiency etc. of funds in the account. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for a discharge in whole or in part of any debt or other liabilities is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceed the amount arranged to be paid from the account by an agreement made with that bank. Such person shall be deemed to have committed an offense and shall, without prejudice to any other provision of this act, be punished with imprisonment for term which may extend to such and such, or with fine which may extend to twice the amount of check, or with both, provided that nothing contained in this section shall apply unless check has been presented to the bank within a period of 6 months from the date on which it is drawn, or within a period of its validity, whichever is earlier. The payee or holder of in due course of check, as case may be, make a demand for payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of receipt of the information by him from the bank regarding return of the check as unpaid. Drawer of such check failed to make payment of said amount of money to the payee, or as case may be, to the holder in due course of check within 15 days of the said notice. Now, my lord, as for provisions, one has to see whether check issued by the accused or appellant to me was whether present before the bank, whether that check was returned unpaid due to insufficiency of pound or over pound. Then after returning of the check, whether I issue a notice to the accused person or not. This process has been done. Now, my friend tried to project the case that I have no financial capacity, and how it comes, when it comes, where it comes. I mean, let me take my law to the page 23 of the paper book. This deed of agreement. What does the deed of agreement says? This deed of agreement is made on this day of 28th February 2018 at Naharlagan. MS Tanga, the appellant, such and such, and MOI. What is the terms and conditions of this? Now, therefore, this deed witnesses that the first party, the appellant, MS Tanga, Tanga Enterprise Proprietor, Mr. Lokam Talo, received a loan from second party, MOI Enterprises, Proprietor Srimuti Bakeyama. And now, first party paid his loan amount by check. So from this moment, earlier, what business they have deal with, he accepted and he paid. By this agreement, he issued a check. By now, and now first party paid his loan amount by check, detail of the check number, such and such, account number, bank number, bank name of the bank, branch, name of the account, MS proprietor is given. Now, the check received by second party as his refund amount of the loan should be withdrawn in the month of April, 15th of April 2018. And then condition number 3 is if in case of failure, that it's not relevant. By this agreement, the appellant has said that the loan which I taken is repaid by this check. Check number written in this agreement and page 25. Check number, same check, same signature, issued by the appellant. My lord, now issue is whether before the trial court. Since 139 presumption is in favor of the holder, me, the complainant, whether the appellant has raised for any probable defense against this all this agreement, check, his signature, nothing. Even he has not denied of receiving a notice. Instead of doing that, what he is trying to project the case that he lodged one FIR, stating that his check was lost, and the check was not honored not because of insufficient of funds, because of withdrawal, stopping. But he fails to adduce that part of the evidence before the trial court. He knows that he is doing some mischievous work. That is why he could not brought that record, although there was FIR before the police, but he could not adduce. He knows that he is doing some mischievous work. That is also after bouncing of the check, he started doing all these acts. By this agreement, previous transaction which took place between the parties finished. Now entire things started from this agreement. By this agreement, he issued a check for check bearing such and so for rupees 5 crore 72 lakhs. And here made a specific condition. It should be deposited on 15 April. So in 15 April, when I went to deposit the amount, check, he made a call and requested not to deposit on that day, and requested the complainant to deposit the check by first or second week of the July, not on April. So we the complainant accept and deposit on only the month of July only. So notice was after depositing the check, that is page 26 is deposit slip. Then page 27 is return memo, which was issued by the bank. The reason was given found insufficient. Then page 28, a notice was served to the accused appellant. And page 29 is postal receipt. Then page 30 is tracking of the delivers. It was delivered. And appellant accused did not made a specific denial that he had not received the notice. Then after demanding by issuing notice, this complaint was filed. Complaint was filed. Then the onus lies upon the appellant. The entire pleading, entire submission, other than the legal point which he is made, is not made before the learned trial court. He tried to improve the case step by step. It should be raised in the trial court. So after long trial, it was filed in the year 2018. So judgment was passed. The learned trial court examined thoroughly. Although presumption was in favor of the complainant, we have examined 3 witnesses. The 3 witnesses, other than in other facts, they have some inconsistency, but material facts, they are all true. Issuing of the check, deposit of the check, insufficient return of the check, issuing of the notice, there is no any inconsistent by the complainant. It is corroborated throughout. And the agreement. The agreements, in the agreement, he has put signature. In the check, he has put his own signature. In no point of time, he has rebutted that check, the signature. Only he is trying to project the case that he has lost his check. That has to be his proof before the court with cause and evidence that he has lost the check. Such acts of the appellant itself indicate that he is playing a part. Now the issue before this appellate court, revisional court, is whether the finding of the learned trial court or court below, whether it's according to, whether they have appreciated the evidence properly or scrutinized the evidence in a proper way. That has to be examined. The finding of the trial court was upheld or affirmed by the learned session court. And they have detailedly examined, and even the judgment itself is detailedly discussed, entire fact and circumstances. The ground on point of determination, every point of determination has been discussed. So the learned session court has found that the decision of the learned trial court was justified and there is no ground to interfere. And my lord, this NI Act is a social justice legislation. This objective of enacting NI Act is to protect the transaction of instrument. The person is scrupulous person like the appellants. They may always cheat with the innocent people. This only objective of this provision is to protect the transaction, business transaction through an instrument. And this is a social legislation. Now, and every issuing of check and returning check itself is sufficient to convict the accused. No other, unless he raise a probable defense. Probable defense also has to be raised with cause and reason, not by asking one question in a cross-examination. That is a probable reason. Now, my lord, go through the 313 examination of the accused person. Whether he have raised any probable defense by 313 also. All through only he has plainly denied question number 1. CW on Bake Yama deposed that she has given sum of rupees 5 crore 72 lakhs to you for carrying out the road project from Parsi Parlo to Damin under PMJ, for which you have also executed an agreement dated such and such. What you done? I have not taken any loan from Bakema, nor I have executed any agreement with her. The agreement which we are talking is this agreement dated 28 February 2028. 2018. There is her his signature. So he has not said that I have not put his my signature in that agreement. So 28 February 2018 agreement. So he just plainly denied that I have not taken loan or I have not executed any agreement. Now, question number 2. Further deposed that as per agreement dated 28 to 2018, you issue a check bearing number such and such from your account number maintained with Allahabad Bank in favor of MI Enterprise, whose proprietor is with condition that check be presented for encashment on 15/4 2018, that on 16/4, you requested the complaint to deposit the check on 2nd week of July 2018, and accordingly, complainant deposited the check in firm account number maintained with Indian Bank, and said check was presented before Allahabad Bank on 10/7/2018 for clearance. But on 11/7, the check was returned to Droi by Droi Bank due to insufficiency of pound. What do you say? I have not issued any check to Bakiyama. And who has issued this check? Or what is this agreement? Whether the signature is forged by someone, that he has to brought before the court with evidence. After check was written verbally and through notice, demand notice such and such, then I do not remember if I received any notice from the complainant. That also evasive reply. Then regarding giving of 1 crore, CW deposit, even receipt of legal notice, you have failed to. There was my allegation that after receipt of my notice, the appellant engaged one Yumlam Radha to negotiate with me. He also handed over 1 crore as a part payment, but which we have not accepted. Now he is denying that he has not given 1 crore also. He is ready to sacrifice even 1 crore also. Here also he has, I have not paid rupees 1 crore to Yumlam Radha as part payment of the loan. Then number 5, CW to Pingia Radha deposit, he was one of the witness in agreement dated 28/2018, at time of the execution of said agreement. So you having check of rupees such and such, was informed by the complaint that said check was dishonor bank. I have never met Bingia Anthony, though he is from Michael. He is one of the witness in the agreement dated 28/2018. But that witness also he is now started denying. This is same things. Now, last, will you adduce evidence in your defense? He said yes. My lord, after 3 hearings, he stated that I will not adduce any evidence. Then matter was, judgment was passed. Since from the very beginning, he was delaying the matter. So my lord, my humble submission is that the learned trial court as well as session court judgment is absolutely clear and is justified, is absolutely right. They have taken right decision. And whatever my friend submitted before this honorable court is, it was not raised before the trial court. Now he is trying to improve the case, and he is trying his best to improve the case. And even in appeal before the session court, one of the ground is that the advocate learned counsel before the trial court has not, they try to blame the advocate appear before the trial court, has not guided properly. Now, inter which he has raised, submitted is not in ground which he has made in the appeal as a revision petition. It's not the ground which he has raised in this revision petition is that the learned trial court has not appreciate this and that. None of the submission which he has made before this court is the ground which he has raised. Some of the ground which now he has raised, the learned court has passed judgment without application of mind, critical thinking, did not examine the deposition of witness in true perspective, not consider material aspect, did not appreciate evidence on record, were not appreciated in light of settled law, ingredients of offense and regarding legally enforceable debt or liability not prove, ignore settled provision of law. These are the ground. In the before the session court, there are around 15 or 16 ground. Now it has been improved to 30, more than 30 ground. Yes, right. So, my lord, without bothering my lords, since this judgment was passed with, I think, all the judgment laid out by us, judgment passed by the learned Supreme Court and all the judgment. And now I want to submit 3 additional judgments. One is regarding this is criminal FL number 123/2021 arising out of this bill. MS Kalamani text and another versus Bala Subramaniam. This case is fact is almost similar to the present case. Here also the appellant tried to raise the financial capacity of the complainant. The Bir Singh case is referred here. The specific paragraph is now second case is this is 2012 9 SEC 4 page 460. Relevant para will be my lord para 12. So section 397 of the code vests the court with power to call for and examine the record of an inferior court for purpose of satisfying itself as to legality and regularity of any proceeding or order made in case. The object of this provision is to set right patent defect or in error of jurisdiction or law. There has to be well-founded error, and it may not be appropriate for the court to scrutinize the order which upon the face of it bears token of careful consideration and appear to be in accordance with law. If one look into the various judgments of this court, it emerges that revisional jurisdiction can be invoked where decisions under challenge are grossly erroneous. There is no compliance with the provisions of law. The finding recorded is based on no evidence. Material evidence is ignored, or judicial discretion is exercised arbitrarily or perversely. These are not exhaustive class, but are merely indicated. Each case would have to be determined in its own merit. So this is regarding the regional.
Same judgment I was.
Then Dalmia Cement, that I think is already referred in the, this is objectives of the negotiable instruments. And regarding that figure in the cross agreement is a typical mistake. 772 crore is a typical mistake. It was not stated. Since in every, even in a complaint, in my examination in chief, and even in the judgment, it's 5 lakhs, 5 crore 72 lakhs. 7 crore 70, it is erroneous, typographical error. Now regarding the non-implement of the farm as a party. So Lokam Talo, he is the proprietor. This is MS Lokam Talo proprietor MS Tangga Enterprises is mentioned. So he represents the farm and check is issued in his signature, not by any of the director or any of the representative of the firm. So this issue has, this is a social legislation. This technical issue should not be bring into, it should not affect the rights of the complainant. Regarding my lord, regarding enforceable debt or liability, there is clear indication that they executed a road project amounting to 40 crores. While doing that, my husband and they have some partnerships, they have invest, and taking into account all these things, now he has issued a check with an agreement. I have taken loan. Today I am returning the loan amount by giving this check. Check number is there, his signature is there, palm seal is there. Then what more the complainant has to establish? So the presumption was completely in favor of the holders. So it is onus upon him to rebut that presumption, which he have miserably failed to do. Even from the record which we have brought, from that angle also, he has not raised any probable defense. Probable defense has to raise with cogent reason. Not merely just I have not issued check, I have not drawn an agreement. That is not a cogent reason. That cannot be accepted, my lord. Now, this is a pit case where this, my lord has need not to interfere, since the judgment of the trial court as well as the learned session court is beautifully written. My lord may go through thoroughly. And my humble submission is that this appeal has to be dismissed with cause, since he has caused so many delays. For long, it has to be disposed of. Okay, all right. So my humble submission is this appeal should be dismissed.
Reply. Just 2 minutes reply I'll just give, because my lord, certain, now my lord, he says that there was a stop payment. So had it been a stop payment case, we should have reduced evidence. My lord, to whatever little I understand, a thing admitted need not be proved. It is her witness admission that yes, such and such letter was received from the bank, which says that it was not because of insufficient fund, but it is because of stop payment. It is her evidence. So she admitted. Then, my lord, they say that since the trial court has given a detailed reasoning trial court has, and the appellate court has given detail. My lord, if that be so, then why the parliament have given power under 397 to the High Court for revision? If trial could have been, if trial court is the last word or appellate court is the last word, then the parliament would not have given power to this honorable court to exercise power of 397 or 401, my lord. Now, my lord, he was relying on one judgment that is 2000 and this Dalmia Cement to say this financial capacity and something, and that he has failed. My lord will kindly see para 5 of that judgment which he has relied on. In para 5 of that judgment, the complainant admits his liability and say that it is my inability to pay the debt. On that context, my lord, every judgment is rendered on its peculiar facts. My lord, what I am saying is that my burden will come provided they lead cogent evidence, provided they discharge their burden, which is beyond all reasonable doubt. And to rebut my burden, to discharge my burden, I need not adduce any evidence, my lord. I have already shown all this judgment. I can rely on the cross-examination part to discredit their own witness, meaning thereby that I can rely on the material submitted by them. And my lord, your lordship has seen, I will not repeat, that the cross-examination part are self-damaging, my lord. And they say that now it is a typographical error 7 crore. My lord, have seen that if one of the witness they have recalled for re-examination, one of the witness there is a re-examination. If this is a typographical error of such magnitude, then that could also have been corrected by re-examining him when it has come to knowledge, or it could have been brought to the notice of the court that there is a typographical error. Something could have been. Now, my lord, after so many years, then, my lord, I will also say this entire check is a typographical error. This is a typo. So this will not. Now, probable reasons only when, yes, and this 2000 and this financial capacity judgment, which my friend was relying, that was of 2012. My lord, I have already, the judgments which I have relied on financial capacity, your lordship will say this is 2023 judgment. That is precisely what I said. Initially, the law was that if you don't show financial capacity of lending, then your case fails. Then Supreme Court has diluted it. Supreme Court says, okay, financial capacity, you'll have to show financial capacity when it is questioned. And therefore, 2023 judgment, that when it was questioned, he could not. That's my case, my lord. Rest. And the revisionary power, my lord, already in that written argument, my lord, I have given. This is the revisionary power of the, because it is a perverse. This will grossly erroneous because the evidence has not been. But and my lord, he's saying that one interesting part of the appellate court judgment, only one paragraph I'll show you. Just such self-contradictory judgment, my lord. My lord will kindly take the paper book, page number 92. This is an appellate court judgment. I'll not say much, my lord. I'll just indicate this para. Rest, your lordship will understand, my lord. Page 50, page 92, para 52.
Para 53.
My lord, have seen page para 52?
Yes.
My lord will see the last para. Even for the said purpose.
Wait.
Right hand side, even for, it starts with even for. Para 52, page 92, 1, 2, 3, 4, fifth line from bottom. Para 52, which starts with even for. My lord, it is somewhere here, my lord.
While rebutting.
Even for. Yes, my lord will kindly see. Even for the said purpose in the sense she is saying rebutting purpose. The evidence adduced on behalf of the complainant could be relied upon. She says this. Next line, what she says? However, in the instant case, the appellant accused miserably failed to rebut the presumption and failed to adduce any evidence. So, line 1, she says that you need not adduce evidence, you can rely on the evidence of the complainant. Line 2, she says, I failed because I did not adduce evidence. There are such material contradiction, my lord. My lord will again, my lord, this session court was exercising, my lord, appellate jurisdiction, my lord. Now kindly see page 93. What jurisdiction she has assumed? Para 56. She has assumed revisional jurisdiction. She was under impression that she is a revisional court. I did not point out all this because, my lord, at the end of the day, it's a session judge, so I thought of, but since a submission was made that these are all correct, my lord, there are many such inherent contradictions in this judgment. Can this judgment stand, my lord, when a judge who is an appellate authority is assuming the role of a revisional court, and she's saying the settled principle of law is that it is not for the revisional court to reanalyze and reinterpret evidence. The law is absolutely otherwise. Firstly, she's an appellate court, and she is duty bound to appreciate and reappreciate evidence. So these are inherent contradictions. There are many such, my lord. I don't want to take, because on the facts I have shown, my lord, the record. And now see, my lord, without appreciating the fact, what she does, page 55. She is completely relying on the finding of the trial court, para 55, page 93. The learned court below, after going through all the materials on record, evidence of the complainant, and after going through decisions of various judgment, has rightly observed that the accused has taken a vague defense and not placed any cogent to rebut the presumption under such and such, and as such, the accused has failed to discharge the initial honors by showing the non-existence of the consideration. And as such, trial court have discussed, therefore, you have failed. Is this how, my lord, an appeal is dealt, my lord? Rest, I leave it to your lordship, my lord. That is, there is just one or two such, my lord, legal jurisprudential error, my lord, which is there, my lord. I'm deeply obliged.
Mr. Bhattacharya, this is your item probably. Last item. Yes, sir. And this is, I'm going to appeal today because once CAV I have already collected. I don't want to collect another CAV.
Lordship, it is pending from the month of September, and I have been told that my friend will perhaps not be able to address your lordship. So let me do my part today. She will do it on any other day.
On some other day. Next month you do it.
Today, tomorrow, lordship.
No, next month.
Next.
I don't want to collect it as a CAV. Today this I have collected the CAV. Another CAV of 3 months old CAV is still in my custody. So I don't want to.
Lordship,
collect
let me
another
do
CAV.
my part, lordship, then.
No, we do it in the month of August. What September?
Any part in the first week of September, lordship. 4th September? 4th September, lordship.
Okay.
That will be Thursday.
Heard Mr. A. Bhattacharya appearing for the appellant. Heard MS H. Hagedillar, the Regional Body Prosecutor for the State of Assam. The hearing is adjourned today. List on 4th of September for hearing.
Let us see, lordship, that we do it on that day, because it is 1,174 days, lordship, is in custody, lordship. It's going to be around 3 years.
It will be done on that day.
Lordship. I'm deeply obliged.
4th of September. Call it.
I appeared for the respondent number one for the state lordship.
Additional PP you have retrieved.
Yes, lordship.
Yes, my lord.
Yes.
This CRPC is filed on non-registration of the FIR, Your Honor. Non-registration of the FIR being filed by the complainant petitioner.
Non-registration of the FIR.
Yes, Your Honor.
Then what happened?
Your my lord.
You filed a complaint case.
Sorry, my lord.
You filed a complaint case.
Yes, Lordship. Which was dismissed, Lordship.
Dismissed by the CGM, Your Honor. By appreciating the status report of the IO officer in charge, by considering the incident as a civil in nature. Whereas IO is not authorized to determine whether the case is civil in nature or not, Your Honor.
Where is the order of the CJM?
CGM order, Your Honor. On page number 46.
46.
46, 47. Your Honor.
Operating procedure para.
What is your name?
Hayadon. Tidon.
Art Mr. Tidon.
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 Tidon. D-O-N.
T-O-N.
Tidon.
Tidon. No. Appearing for the petitioner. Art Mr. Louis. Yes. Related traditional public prosecutor for the state of Orange. This application has been filed under section 528 of the BNSS 2023. Challenging the order dated 21/04/2025, passed by the learned Chief Judicial Magistrate, Civil Judge Senior Division, Lohit District at Teju, in criminal complaint number 03/2025. The petitioner initially filed complaints in the police station. He states that his complaints were accepted by police and no case was registered. Therefore, he filed a complaint case in the court of the Chief Judicial Magistrate, Teju. In the meantime, the officer in charge of the Teju police station submitted a report to the Chief Judicial Magistrate.
Sorry for interruption, Lordship. Before filing, they approached the superintendent of police, Lordship.
On the basis of the said report, the trial court held that the dispute raised in the complaint is a civil dispute, and on the ground advised the complainant to approach a civil court, and the complaint petition was dismissed. I have considered the submissions made with para. I have considered the submissions made with the learned counsel of both sides. Para. On the face of the report, the impugned order is bad in law. Whenever a complaint is filed under the provisions of the BNSS 2023, the complainant has to be examined. Apart from the complainant, some witnesses may also be examined by the trial court. Thereafter, the trial court can come to a decision whether to take cognizance or not. Here in this case, the impugned order is based on the report of the officer in charge of Tezu police station. Not on the basis of the evidence of the complainant or his witnesses. Therefore, the impugned order is set aside. The learned judicial magistrate is directed to examine the complainant and his witnesses if available. And thereafter, the trial court shall dispose of the matter in accordance with the procedure as laid down by law. With the appropriate direction, the revision petition is disposed of.
I'll have this. My lord, I beg to mention item number 18, we could not reach when we have been called, my lord.
It is already gone. We come on the next section.
Can I make a prayer also? Number 23, can it be fixed on 14th August? Huh? 14th August, can it be fixed? I think
On 14th August.
14th August.
You want it on 14th
of my colleague also.
14th August.
14th August.
The instead of 4 September, 14th August.
I'm different.
Much of.
Yes. 8 and 9.
Yes, my lord. My lord, this was fixed for hearing today, my lord. It was fixed for hearing today, my lord.
It will go for hearing.
It was fixed for hearing, my lord. The opposite party is not present today, I believe.
Opposite party not present. Item number 8. How do you say MAT?
R. Jagwani, my lord. R. Jagwani, conducting counsel.
Your name is?
My name is Jeetalo. I'm in item number for respondent in item number 8 and for petitioner in item number 9.
Oh, sure. So in item number 8, the petitioner is absent.
Yes, my lord.
In item number 8, you write petitioner is absent on call. Heard Mr.
Jeetalo, my lord.
Jeeta Talo. AP for the sole respondent.
Yes, my lord.
Since none appears for a petitioner on call, the matter is adjourned today. Least up to 2 weeks for admission hearing, along with item number 9.
Yes, my lord. My lord, in item number 9, there is an interim order that may be kindly continued, my lord.
Right here, the interim order passed in criminal petition number 212 of 2023 till the next date of listing.
Much.
It's finished.